Yeah. So, yeah. I'm glad it turned out. It's for the best. All of it. Still there. Still. Yeah. Wow. You guys do that. Well, hopefully that doesn't.
No, I'm about to get one. I'm about to get my calendar out for you. Miss Abby, have you guys, what are some dates that we can maybe set this beyond? I really care.
What month are you thinking?
Huh?
What month are you thinking?
I don't care if we end just.
We could do.
It's a petition for contempt of trade pay child support, a few, and a couple of alimony payments.
August 7th, 28th, and 29th.
August 7th.
28th.
I've got Richardson versus Richardson on the 7th in Dixon.
Can you do the 28th?
The 28th, I've got Cato versus Cato and Etheridge versus Etheridge.
29th,
I've got Petty versus Petty, all in Dixon.
September 3rd.
All rise. The Humphreys County Chancery Court is now in session. The Honorable Judge David Wolf present presiding. All who have business draw near and be heard. God bless the state of the United States and this honorable court. You may be seated.
All right, good morning. We're going to start with the call of the docket. Call the first case.
Docket number 2025 CV 62 regarding Alexander McKinnon by John McDonald and Brandy McDonald versus Douglas McKinnon.
Good morning, Your Honor.
Good morning.
This is a petition for adoption by step parent with consent. This is the McDonald family here. This is John and Brandy, and this is Alexander here in the middle.
All right, everybody's going to testify. Raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth to help you God?
See, that's part of the job of a father, is to tell his son what his right hand is and what his left hand is. So he'll help you figure that part out. All right, Mr. Noel, go ahead.
Brandy, I'm going to start with you. Please state your full name for the court.
Brandy Wyoming McDonald.
And are you the mother of Alexander Earl McKinnon?
Yes, I am.
And is Douglas Earl McKinnon the biological father of Alexander?
Yes, he is.
And you came to my office and we drafted a petition for adoption by step parent with consent. And Mr. Douglas McKinnon executed that document.
Yes,
Correct?
that is correct.
He also executed a notice of informed consent. And you're here today to present this petition and ask that your husband, John Wayne McDonald, be allowed to adopt your son, Alexander.
Yes,
Do you believe that is in Alexander's best interest?
yes,
are you and John financially, physically, and mentally capable of providing for Alexander?
Yes,
And has John served this role for some time, his father?
he's been in his life for 5 years. So yes,
And do you believe it's in his best interest,
Yes.
Alexander's? Now, do you understand that in the event that you and John were to divorce, that either of y'all could get custody,
yes,
either of y'all could pay child support,
yes,
and you're willing to accept that and believe it's in his best interest?
yes.
Will you please state your full name for the court?
John Wayne McDonald.
You can come over in front of the microphone if you like.
John Wayne McDonald.
And Mr. McDonald, did you hear everything your wife said?
Yes, sir.
Do you agree with it?
Yes.
Do you understand that in the event that you and Brandy were to divorce, either of you could be responsible for child support,
Yes, sir.
that either of you could receive custody of the minor child,
Yes. Yes.
and that from this point forward, he would be an heir at law of yours and you would be an heir at law of his if the court grants this adoption?
Yes, sir.
And do you accept all of those rights and responsibilities?
Yes, sir.
And do you believe that to be in Alexander's best interest? Are you asking to change his surname from McKinnon to McDonald?
Yes.
And his name will be, if the court grants this, Alexander, Alexander, Earl, Earl, McDonald, MC big D Onald.
Yes.
Is that correct?
Yes, sir.
Now, Brandy, Alexander is not an Indian child, correct?
No.
Native American child?
No.
Okay, and he's not been brought into this state for adoption purposes in any way.
No,
Y'all reside here in Humphreys County, Tennessee.
yes.
All right. What's your name?
Alexander Earl McKinnon.
Okay. Did you hear what these folks said today? Is this your mom? Is this your stepdad? Do you want him to adopt you?
Yes.
You do? Okay. You good with your name changing?
Yeah.
Okay. Judge, that's all the
I
proof.
rarely see anybody quite as excited as he is to appear in front of me, but I'm glad to see that he's happy about the situation. Mr. McDonald, the main thing that I have to make sure of is that you understand the change in your status that will result after today. Being a step parent is a difficult job sometimes, and it's a compliment to you and to Mrs. McDonald that the two of you have such a good relationship, and you've had such a good relationship with this young man that he wants you to be his father. And that's a huge compliment to a stepdad. So we'll be changing the nature of this situation today, and that will be changed from that of a step parent to that of the same as if you were his biological father. So in every way, shape, form, and fashion under the law, he will be your son. And you understand that? Do you have any other children?
Yes, sir.
How many children do you have?
I have 2 more.
All right. You got any boys? All right. So you know what you're getting into. So,
I was adopted myself.
oh, you were? Well, then you understand that this is what they say, paying it forward. I think that you're able to return the favor to a young man who obviously looks up to you in every way. And I'm certain that as the years go by, this will only solidify into an even greater bond that the two of you have. So, Ms. McDonald, it's a great compliment to you that you have a young man that looks up to his stepfather so that he wants him to be his dad. And I am happy to grant this. Ms. Honeycutt, you arrived. Are you involved in this?
I was the guardian. I've been his guardian ad litem for many years. I was the guardian ad litem in the underlying case. So I'm happy to see this happen.
All right.
And then I have a motion to approve attorney fees in the underlying
All right.
case as well. Ms. McDonald has already paid her portion, but I submitted the invoice so I can send a bill to Dad.
All right. Okay, well, everything seems to be in order, and I'm happy to grant the adoption. So congratulations.
Thank you. Thank you. I assume I can draft an order for the approval of.
You can.
Congratulations. Congratulations.
Don't ditch it. Is that okay, Judge?
Yes, absolutely. Come on up here. We'll let you sit in a big chair if you want to. We'll all stand on one side. So what are you gonna do? You want to sit?
Yes.
All right. You want the gavel? There you go.
Oh, man.
There you go.
All right, guys. Here we go. 3, 2, 1. All right.
Congratulations. Congratulations to you. Take care. Xander, you can carry this with you and that'll be your own individual gavel you can use in school. You're welcome.
I got the band.
All right.
Yes.
I signed the original one that's filled in on this. I signed this one, so this one needs to be trash. This one.
And then this next one is open. 2021 CV 99, Christy Thornberry versus Tristan Thornberry.
Tristan Thornberry.
He's in Dixon County Jail, last I heard. I think he's.
I'm here, sir.
Okay.
I'm on the screen on the Zoom meeting right now.
All right, we need to turn the video on. There we are. All right. Let me take a moment to look and see what this is about.
Yes, sir.
Okay. All right, my understanding is that Mr. Thornberry has filed this Rule 60 motion on February the 21st of 2025, seeking to correct an order that was entered on October the 22nd of 2024. His basis is that the parenting plan that was shown in that final decree or that order that was entered listed his income at $5,083.33 per month, when his income has been zero since April of 2024, since he's been incarcerated on pending charges, and that he's asking for the relief to amend the financial support section of the plan to acknowledge that he has no income. So, Mr. Thornberry, if I stated correctly what your statement is, what you're asking?
Can you say that one more time? I'm sorry, the audio here is not really good.
I understand. It's my understanding that you're asking to amend the parenting plan that was entered back in October of 2024 because of the fact that it incorrectly lists your income at $5,000 plus and that you have been incarcerated since April of 2024 on pending drug charges. Is that correct?
Yes, Your Honor. There was a few other points that I wanted to try to address while we were here today, but that was one of the main ones that I had sent in. I had sent in a few motions to the court that the clerk's office had received. One of the other things that I wanted to address, if I can speak freely.
Well, if you're going to testify about what you want changed, then I need you to raise your right hand. Let me place you on the road. Do you solemnly swear or affirm the testimony about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. What else are you asking for?
I was gonna try to address the no contact order that the plaintiff has said has been in effect since we last went to court. I wrote a cease and desist letter that I actually sent to Mr. Hawley and to the clerk's office, asking them to, let me know about the no contact order that the Christie said that she had. I wrote the clerk's office asking them to send me anything on file that they had saying that there was no contact order. Our parenting plan doesn't have a no contact provision in it or anything. I haven't been allowed to talk to my daughter for the duration of my stay while I've been incarcerated. And the second point that I wanted to see about is letting my dad, who's here in the courtroom, and my stepmom utilize my parenting time so that I can adequately visit and communicate with my daughter. Because I don't believe that at this time that the mother will be willing to accommodate those. That's all, Your Honor.
All right, Mr. Hawley,
Judge, we did not know it was
you
set
need
for
to
today.
speak before the microphone for him to hear you.
I think, well, we didn't know that it was necessarily set for today. I don't know if it was set today to get a date to hear his motions or whatnot. Mrs. Thornberry is not here. I haven't reviewed the file, so I'm shooting for the cut. But I would say, number one, we would be opposed to him reducing his income. Obviously, it's what he should have been making. He's in jail right now, and of course, the rearage is still sitting there. I understand it's a zero income, but he's there on drug charges and domestic violence charges and things of that nature. Nonetheless, to have a chance to,
according to his information, he was in jail at the time of the last hearing, and it does show that when an order went down to suspend his visitation, that he was actually appearing by Zoom from the Dixon County Jail on that occasion. So my belief is that clearly, if he was incarcerated, I understand your argument about the fact that he may have a willfully unemployed or underemployed, that you may have that argument to make because he's incarcerated, but it's pointless to set a child support amount when he is unable to do it. Mr. Thornberry, I'm not asking you to go into the facts of the case, but according to my review of the file, it appears that you are charged with 2 counts of attempted first-degree murder and some drug possession charges. Is that, without telling me what happened, is that the charge that you're facing?
There's 3 counts of attempted second degree, 1 count of Schedule 1 drug possession, 2 counts of domestic, and then 1 count of resisting arrest.
All right. Well, let me just deal with this first and foremost. In my opinion, the suspension of your visitation has been properly heard by the court. You were given an opportunity to be present, and there's no basis to set aside that order because of the fact that you are currently incarcerated facing very serious charges. The order states that the suspension of your visitation would occur until such time as you are released from incarceration. Now, what that means is that as long as you're in jail, then you're not going to be able to see your children. Now, whether or not grandparents have a right to visit under a statute, that would be determined. The grandparents would have to file a motion for a visitation under the grandparents visitation statute, and that has not been done in this particular case at this point. But I cannot simply substitute your parents for you as far as the visitation goes. So under the circumstances, it would seem to me that the best thing I can tell you is I am going to suspend any order that sets his visitation or his child support at the current time based upon the fact that he is incarcerated and was incarcerated. I will suspend any operation of any child support order until such time as there could be a further hearing. And then that will give you an opportunity to have your client. I'm not back here until October, so it would be October before that portion can be heard. When it, again, not going into the facts of the case, but you have a lawyer, I assume, that's representing you on the criminal charges.
Yes, Your Honor. I go back to court October 28th.
Roger Wayne.
Yes.
Roger.
Yes, Your Honor.
All right. When you need to contact Mr. Wayne and just, explain to him what's going on, but I don't want to have you testify about your criminal, where you'd be subject to a cross-examination. And so for that reason, I'm just going to put an order down that suspends the operation of the parenting plan as to the child support calculation based on the fact that you're incarcerated and have no income at the present time. Your motion to alter or amend or do away with these no contact order is respectfully denied based upon the fact that you're incarcerated and have, in my opinion, there's no basis upon which I can find that there's any change from the prior hearing. So you can renew that if you choose to by filing something and having it set in October. But if you want to have this child support issue heard in October, we can set it on a day in October. Give them a date, please.
We could do October 1st.
October 1st.
I'm fine on that day.
We're going to set it on October 1st for us to review both the visitation aspect as well as the child support issue. Okay.
Okay.
10:30
At 9.
at 9. Okay.
I'm
9
sorry.
o'clock.
You said
October
October
1st.
22nd, is that correct?
No, October the 1st.
Okay.
That's the date. All right. Thank you.
If I'm correct, Judge, you're suspending basically the collection part of the child support, which is fine. We weren't.
Calculation of child support under that parenting plan is suspended based on the fact that he was not employed at the time that the order went down and has no income. So as a result of that, since he's still incarcerated, I think it's pointless to have that calculation in place. So we're granting your motion regarding calculation of child support until a hearing on October the 1st. Mr. Thornberry?
So the child support that's in arrears right now, is that going back from whenever the new plan went in place or from this day? Just for
I
transfer.
have found that the child support calculation was an error based on the fact that you were incarcerated at the time, and therefore it should not, but we'll deal with that on October the 1st.
Okay, thank you very much, Your Honor. I hope you have a blessed day.
Thank you.
Thank you.
Call the next case.
2025 CV 49, Tommy King Jr. versus Megan King.
Good morning, Your Honor.
We skipped over the McDonald one, but that's because we did that. All right, this is the King versus King.
Yes, Your Honor, this is my case. Mr. Keene is present in the courtroom, sitting back here to my left. This is a divorce case. I see on the docket there's been a motion to continue. I didn't get a copy of that, but I see that it's in the file. I've looked at that this morning. So this is a divorce case that we filed. Mr. Keene's wife filed a divorce in Utah prior to our filing the divorce case here in Humphreys County. Mr. Keene has retained counsel in Utah and has challenged jurisdiction and venue there. There's a hearing set, I think in a couple of weeks, maybe July the 15th in Utah regarding that issue there. That's kind of where we are today. What's on the docket other than the motion to continue is my client's motion for some temporary parenting time. He's not seen his children in person since she left and took the children back to Utah. And so that's obviously something that he's desiring very much. So that's the status of the case, Your Honor.
Good morning, Your
You
Honor.
want
Abigail Lang for the respondent. We're just asking that we continue this case until the motion to dismiss in Utah is decided upon. We believe that this case should be in Utah anyways, but obviously there's filing here for divorce here as well. My client filed in Utah in March. This was not filed, I believe, until May. So we're just asking to let us figure that out first before we have to maybe come down here for potential divorce and custody proceedings.
Well, obviously, it's kind of pointless in a sense for me to have a hearing if, in fact, Utah is going to assert jurisdiction and the facts support that finding. So it does seem to me that the more beneficial way of handling it Although I have had a case recently where we went forward with the hearing and I concluded that we did have jurisdiction, but that was essentially before me on a question that was raised by both parties as to whether or not this court had jurisdiction or the court in another state had jurisdiction. And after I heard the facts, I found that Tennessee had jurisdiction, and I put an order down to that effect. And the same request was made that California in that case had jurisdiction. And California court had a hearing, and I just simply made my findings and reset the matter for the California court to decide what they thought. And the California court found that Tennessee had jurisdiction and dismissed that action. So it seems to me that in this particular case, unless we're going to go forward today with a full hearing about the question of who has jurisdiction, that we can reset it after that July 15th date and let the Utah court make a determination. And then after that, we'll know where we are. So, it doesn't rob me of jurisdiction just because Utah has asserted that they have jurisdiction. So we'll see.
I'll supply everything to his attorney in Utah in case that court thinks it needs to speak.
There is a provision of the law that the Utah court can reach out to me to determine whether or not we can agree on which court has jurisdiction. So, and I've had those conversations on a number of other occasions, but in this particular case, I have not been contacted by the Utah judge to know that. So if there is a request for that, then I'll certainly be glad to do that.
And depending on what happens, I take it that I know you'll be back here in October, but you haven't heard anything related to this case. So
you can set it in front of any judge after that determination is made in the state of Utah. I don't have to hear it. So.
Okay. Thank you, Judge.
Thank you.
2024 CV 124, Michael Butler versus Lisa Butler.
You know, this is Ms. Duke's motion to continue. I don't oppose it. We just need a date to reset it. Are you available the 14th of July?
I can't set anything up.
Okay, that's all right. Well, yeah.
You can't say anything else on.
That's when I had originally said it, and then they told me I could set it that day. I still had it down on my calendar. I had it on both.
Apparently, Judge Wallace has advised he cannot say anything else on that day.
You need another date?
We do need another date just to set it in case we can't agree, but I think we'll probably be able to reach an agreement on it.
I don't think Ms. Roberts is available in August, the date that we have.
On the August dates, those are double dates, and I've already got everything set.
September 3rd.
You also have a Jones versus Jones case that's next, and you have a motion to continue in that.
I do.
Yes. And our only issue, and I don't know if Your Honor reviewed the motion, is the mental health of the minor children. It'd be the only reason that we would need to.
What's your
press
reason?
forward.
I haven't looked at the file yet. What's your reason for a continuance in that case?
Well, there was two reasons. Number one, inappropriate notice. We got it on Tuesday. Under the rules of civil procedure, we're entitled to 5 days notice, 5 working days notice. We were not provided 5 working days notice. I got it at 5:03, emailed to me. And again, just getting ready for it. Ms. Duke has made some accusations that are going to take this will be an all-day hearing.
If I may briefly respond, it was sent by certificate of service on the 18th, and so we complied with the rules of civil procedure, and then I also emailed it at 2:00 on the 23rd.
So
what are your issues regarding the urgency of it, Ms. Duke, in the Jones case?
A few of the minor children are going to have to be in significant therapy based on the continued threats of the father and the bad mouthing of the mother and some things that he's doing to try to manipulate the children.
And that's contested.
The children are here if Your Honor needs to hear from them.
And again, the second reason is I had a deposition scheduled with Ms. Duke's law partner at 11 o'clock, but late Friday afternoon, Mr. Vandervoort filed a motion to continue, and we heard that in front of Judge Turnbow, and he granted the continuance. So that was the other other reason for the continuance in my motion, but that resolved itself. But it did lead to the fact that I got this and had no time for preparation. And so we just need to continue.
What about, the 9th of July?
The 9th of July, I have Judge Lockhart Mashes in Dixon, and I have
I'm
Carbone
thinking
versus
is give you
Carbone.
a date for both of these that you may
Bugle.
have to hear it out of county because someone else will be here in July.
Judge, may I approach off of the video?
Mute this, please.
I don't like for everybody to know that I'm going out of town from the 5th through the 12th of July.
That was the reason we were moving Butler.
Yes.
18th.
18th of July.
This is all contingent upon you agreeing to hear it out of county because I'm going to be in Cheatham County, but I have that date available. And other than that, I could give you the,
As far as I know, I try to keep Fridays
I could
open.
give you the 29th.
The 29th, again, that's Judge Lockhart Mashes, Dixon, Chancery, and I have a Bradford versus Bradford, and then a final hearing in a Crispin
Would you
versus.
rather hear this one on the 31st than this bump to the Bates case?
Now, I can do the 18th. I don't know that.
I have a matter that the Hickman County Court set, but I will file a motion to continue on that one. So I can do July the 18th. It's important that this be heard.
And we're doing Butler mediation on the 16th of July. So hopefully we can get a date on it. We'll just work together to get a date on it after the mediation.
All right, so at this point, we're gonna set the Jones case that Ms. Roberts is asking for continuance on the 18th of July.
Yes, and can we admonish both of the parties to verify that nothing is to be said about this? That is our major issue. The kids are calling and crying, and we would assert that we've got text messages to back up everything that's been said in our motion.
I'm not gonna assume the facts in the case. Are the parents here, both sides?
They are.
Bring them up.
You will keep your hands out of your pockets, please.
Mr. and Ms. Jones, we're moving heaven and earth to get you a date to hear this motion that's been brought up, and there's been allegations that have been made by both sides about the situation. I'm not assuming that any of those facts are true, but what I'm going to tell you is this. I'm putting an order down today that you two are not to discuss this case with the minor children, period. You know, is there a guardian ad litem in this case?
I think we need one at this point, Judge.
I'm not opposed. I don't know that there's funds available to do it. It's a private case, but if we're never opposed to one, that's fine. We would just ask that both parties be ordered to make a deposit with that guardian ad litem up front.
Well, the reason the guardian ad litem is even being discussed is because of the fact that you've got minor children in the middle of this. You both may be fine people. You both may be good parents in your mind. And that's good. But my main concern and the main issue that I have in this case is to protect the best interest of the minor children. So if that causes me to have to come down hard on one of the two of you, so be it, because my interest is trying to protect the children. But by the same token, children are very perceptive and empathetic to their parents. And if they see one of their parents upset about something, then they naturally will, try to side with that parent, and they will naturally try to empathize with that parent. So let's try to shield the children from whatever's going on between the two of you. Let's don't involve the children. And I say it in a very nice way, but I'm telling you, I'm ordering you not to involve these children and not to have the children influenced, not to discuss this case with you about this. If they have questions about it, you just tell them, honey, I can't discuss it with you because that mean old judge told me he put me in jail. You don't have to say it like that, but that's exactly what will happen. If I find out that you two have broken my order, then I'm going to put you in jail because I fully and firmly believe it is in the best interest of your children not to be put in the middle of this situation. Children are, used to having both parents. That's the home environment they had, and now that's blown up. Why wouldn't they be upset? I mean, that's a natural reaction to the fact that what they thought was their cocoon of protection and the home that they had is now no longer there because their parents can't get along and they're going to go through a divorce. But under the circumstances, you two can still make it okay for your children by protecting them from being exposed to all of the negativity that a divorce naturally brings about. Allegations may be made. Those allegations would have to be proven in court. I understand that children may be called to testify. I think that's a very regrettable, but sometimes a very necessary step to be taken. But that's the reason that I'm considering a guardian ad litem being appointed is the fact that the children need somebody to advocate on their behalf. Now, Mickey Furlong Smith is the one that I generally use in a lot of cases. I would simply suggest, since I've set this hearing for the 18th, that you two need to check with her and make sure she's available. Before I know she's out of town
She's
right
in
now.
Chicago right now. Yeah.
So it would be my opinion that you need to check with her and see if she's available on the 18th. If not, we need to get somebody else that is available.
Yes, sir.
And there are other individuals who can do that. Lynn Coffinberry is another one that we use on a regular basis. But let's find a guardian ad litem that's available on the 18th so that we can do this.
Yes, sir.
Where are we gonna hear this? Which courthouse?
Courtroom 5 in the Justice Center,
In Dix, okay.
Charlotte, Tennessee.
You just said you were in Cheatham, but where you're gonna be in Dix.
Right.
And again, some guidance, Your Honor, again, as you are well aware, children and their electronics to stay or something that I didn't necessarily grow up with, but punishment issues when you're taking electronics away from children because of misbehavior, whatever, does that include cell phones? And then escalates into, oh, you've taken my cell phone away from me.
My client doesn't have a problem with that at all.
So again,
But if she's explained to the children, if you've done something, Dad can take phone away. Yeah, absolutely.
Put it in the court order that one of the avenues of punishment. How old are these children?
they range.
We've got 16 and 11 right now.
Well,
There's a set of twins.
I'm of the opinion that if they are misbehaving and there's some reason to do that, taking their cell phones away is better than having a leather belts across the rear end like my father used to do with me. So I think that would be certainly permissible, and the children need to understand that that is not an abusive exercise of parental authority.
And go call the other one on somebody else's cell phone and say, somebody took my cell phone away and I'm being
Just put it in the
abused.
court order that the court authorizes both parents to take the children's phones away if in an appropriate situation as parental discipline.
I will assert with the court that my client has absolutely no problem with that, but it was discovered that one of the children was confiding what was going on in Dad's home, and that's when the child's phone was taken away.
And that is highly disputed with some, and again, that's what they want you to believe, Judge, and I know you're not listening to that, and that's why I ask in a generic sense. I'm not trying to prime the pump that Ms. Duke is trying to do. It's disputed.
You two are good lawyers, but you are kind of like oil and water. And under the circumstances.
Good and bad. I realize that, Judge.
It is yin and yang, is that what you said? And there is some truth to that, whether you like it or not. But under the circumstances, I'm not assuming any of those facts are true. I'm trying to give you an opportunity to be heard where we can establish what the facts are. So let's just try to maintain the status quo and keep the children protected to the best of our ability until we have that hearing.
Yes,
All
sir.
right. Thank you.
Thank you.
Thank you, Judge.
(2025) CV 37, Jackie Holland versus Robert Stephen.
Good morning. You are Jackie Lynette Holland.
Yes, sir.
Raise your right hand. Let's place your hand.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth to help you God?
Ms. Holland, you have filed a request for a divorce, and there's some issues with the complaint that you have filed because on the second page of your complaint, there is a provision under paragraph 7 that states orders of protection and other orders check the box that is true to you. And the first box that was checked is there is no order of protection. And then down below that was checked there and initialed, yes, there is an order of protection now in this court. It will stay in effect until the divorce judge changes it.
Okay, there's not an actual order of protection. There was an order attached to domestic violence, a no contact order attached, but not an actual order of protection.
All right. And there is no restraining order other than the statutory injunction. Is that correct?
Correct.
So your complaint contains certain statistical information. Is that information true and correct?
Yes, sir.
You've also filed with the court a marital dissolution agreement. That marital dissolution agreement purports to bear your signature and that of your husband's. Is that your signature?
Yes, sir.
Is that your husband's signature?
Yes, sir.
Do you believe that agreement fairly and equitably divides all your property and distributes all of your debts? You have provided me with a final decree. I need just a moment to look it over. An order of protection is not is a peculiar matter that is before the court under a specific statute. What you're talking about are bond conditions in a criminal case. All right. I've changed that to indicate there's neither party has a current protective order, but bond conditions apply. All right. Now, I've signed your final decree. You can get a copy of it a little later in the morning, and you need to mail a copy of that to your now ex-husband. Thank you.
Twenty 64, James Johnson.
Morning, Mr. Johnson. Raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You are James Glenn Johnson.
Yes.
Mr. Johnson, you've asked to change your name, and I need to ask you some statutorily required questions. Are you asking to change your name to avoid your just debts or creditors?
Yes.
Are you asking to change your name to avoid criminal prosecution?
Yes.
You have stated the reasons why you want to change your name to William Glenn Stevens Johnson. And is that reason the reason that you're asking to change your name?
William Glenn Stevens was my birth name, and I'm asking to reclaim that.
Okay. So do you want your new name to be William Glenn Stevens Johnson?
Yes.
All right.
And I attached the Johnson because I've got two signs, successive race.
I understand.
Yes.
I'm going to ask you, if you will, to sign the order where it shows that you've approved that, and you signed the new name as well. So, I'm granting your name change, but you'll need to approve that where the X is there.
So sign it
with your new name. William Stevens Glenn Johnson. William Glenn Stevens Johnson. All right, Mr. Johnson, I have granted your name change and signed your order. You can get a copy of it a little later in the morning once we've transmitted it over to the clerk's office, okay? All right, thank you.
2025 CV 69 regarding Kylie Ottenreed.
Good morning. Anyone who's going to testify, raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, this is petition to change the name of a minor child. Is that correct?
Correct.
And you are the minor child. Don't look that minor to me. How old are you? 17. Okay, are you consenting to this name change? And who is the biological mother?
I am.
You've all been placed under oath. Do you testify that you're asking to change the name of your daughter to avoid any criminal prosecution or to avoid any payment of debts?
No.
Right. My understanding is that the last name is Alton, is that correct?
Ottenreid.
That she was given that name at birth, but that's not the biological father's name. Is that correct? Right. And we're asking to change it to Kylie Nicole Elam. All right. And Ms. Elam, you are in agreement with that change, is that correct? And of course, the Wesley Alton has signed off on the agreement as well. So, all right, I will be glad to change your name. I always make that offer that I can change your name to anything you want it to be. If you want it to be Beyonce Elam or Taylor Swift Elam or anything like that. So you're happy with Kylie Nicole?
Yes.
You submitted an order signed off on by both Wesley Alton and your mother, so I've signed your order. You can get a copy of it from the clerk.
Thank you.
Thank you. Thank you.
2025 CV 68 Madeline Forrester versus Timothy Whitfield.
Well, I represent Mr. Whitfield. We're ready for a hearing.
All right, I mean,
He's gonna call the rest of the document.
Ms. Forrester, this is here today on an order of protection and a hearing to determine whether or not the order of protection should be issued for a longer period. There was an ex parte order of protection that was issued back on June the 2nd, and this hearing is designed to determine whether or not you want to have that order of protection extended for a longer period. Do you wish to have that extended?
Yes, sir.
All right, then we'll have to have a hearing. You have the right to an attorney to represent you since Mr. Whitfield is represented by counsel. Do you wish to hire a lawyer?
I'll hire one, yes, sir.
All right. Are you asking for this matter to be reset for you to hire a lawyer?
Yes, sir.
Ms. Roberts, she's asking to hire a lawyer, and I think it's probably in her right to do so. When's the next chancery date after the day?
Well, Your Honor, I'm not aware of any statute that grants her the right to extend the order of protection past the 15 days that it's done. So understanding that if she wants to hire an attorney, then we are not agreeing for the extension of the ex parte order of protection.
The ex parte order of protection is extended by statute for 15 days from the date of issuance, unless it's extended further. To extend it further, we would have to have a hearing, and that hearing would require testimony to be taken from you and from Mr. Whitfield. And under those circumstances, then you are putting yourself at the issue of that. Having resetting it means that this order that was issued ex parte would be expired by statute, but that you would still have the right to come back in on the next day I give you and to have a hearing to determine whether an order of protection should issue. You understand that?
Yes, sir.
And that would give you an opportunity to consult with an attorney and determine whether or not that should or should not be done.
Yes, sir.
then when's the next first available date?
So the lapse will be on the 15th, the 5th of July, Your Honor. The parties have a minor child. So
So the first thing after the 5th is July 7th.
Let's see.
we have just taken Butler off July 7th. I've got to be here.
You have?
I will in the morning. I do. I have a Crichton, James, and a Harvey matter. That are short.
We'll set it for July the 7th in front of Judge Wallace. You need to consult with an attorney as quickly as possible and have your attorney contact Ms. Roberts. Perhaps the two of you can arrive at, through your lawyers, can arrive at some sort of an agreement. Okay?
Yes, sir. I have a petition to establish paternity that will be served on her.
All right.
That is
And
out.
another reason you need to go ahead and hire yourself a lawyer as soon as possible.
Yes, sir.
All right. July 7th.
Yes, sir. Thank you.
On the next case.
2025 CV 58 Calvin Johns Jr. versus Amanda Hoffberg.
This is here on pro se petition for an order of protection, and we have received a call. The clerk's office has received a call from Mr. Johns, and he's indicated he could not come today and was advised that the case would probably be dismissed and he'd be taxed with the court cost if he didn't appear. Is Calvin Jones here? Clerk says that he sounded pretty high when he called, so I'm going to dismiss this case. He's taxed with the court cost. You are, I assume, not in jail over an order of protection. It's something else. All right. Case is dismissed. Thank you. Calls for tax to Mr. Johns. Let me fill this out. All right, come on, let's go.
2025 CV 61 Katie Story versus Robert Story.
Judge, I represent Mr. Story in this matter. It was reset from last week for a hearing for today, and we're ready for the court. I would anticipate maybe an hour or so. I can't get a lot for that today.
All right. Ms. Story, you are here today on the hearing for the order of protection that was issued.
Katie is my daughter. She is here. If you would like to speak with her.
It's not a question of whether I would like, I'm just interrupting you and I apologize. This is not a question of whether I want to or I would like to speak to your daughter. This is your case for you to try. You have brought a petition for order of protection and you have the right to call witnesses according to that petition. It is up to you to prove the allegations in your petition, and you can do that by calling witnesses and testifying yourself. But Mr. Holly represents the defendant in the case, and he will be able to also call witnesses and cross-examine anyone who testifies. So if you have your daughter, how old is your daughter?
10.
You have a 10-year-old child here that you're going to put on the witness stand?
No, sir, Your Honor. I was told by the clerk's office that to bring her in case you wanted to speak to her in your chambers. And that if Mr. Holly or Mr. Story objected, that then she would have to be brought in here.
Well, number one, as I said, maybe the clerk was simply trying to say that if she's a witness, then she needs to come and that's the method by which she would be able to testify. It's not a question of whether I want to hear from her. Question, unlike some other instances, this is I cannot take sides. I can't try your case for you. I have to let you put on your proof and let you testify. Then Mr. Holly can cross-examine you then if you want to call your 10-year-old daughter, then you have the right to do so, but the only method would be if they object to hearing from her in chambers, then it would have to be done in open court. And then Mr. Hawley can put on any proof he wishes to, and then we'll go from there. But at this point, obviously, I'm not going to be calling your daughter to testify. It will be up to you to make that decision. Let's, first of all, this is the last case, is that correct? All right, then are you ready to proceed on your petition for order of protection?
Yes, sir. I was also advised by the detective who, I've been told by both detectives that were involved in this case that I needed to get an order of protection for my daughter. But I was also told that I really didn't need to discuss the case because it could interfere with the investigation. So I'm kind of at a loss as to what I can and
Do
can't
you
say.
and Mr. Story, are you married at the present time?
No.
Is there an order down regarding custody and visitation in a chancery court somewhere?
Yes.
Is that in this court?
No, sir.
Where is it?
That is in Hickman, and I went to the Hickman County Court first and was told that because the incident occurred here and because there was already an open investigation here, that it needed to be heard in this court.
Well, the only thing I can tell you is that if the basis for an order of protection is the fact that there are allegations made against Mr. Story regarding his conduct toward your daughter, then those allegations are going to have to be proven in court. And the only way to do that is to talk about the case if it's under investigation or not. Otherwise, you can choose to not pursue this order of protection and go back to, and consult an attorney and file something in the court where the custody order was down to try to get something addressed in that court rather than this court. But even then, the allegation would have to still nonetheless be discussed in order for a judge to make any sort of modification of the prior order. So it can't just be that, allegations are made and now we're going to change everything regarding a custody order. You have to be able to put those facts in the record, and they have to be tested by cross-examination, and then they would have the opportunity to take the stand and to testify themselves. If Mr. Story wants to take the stand in this hearing and put himself subject to cross-examination by you regarding these allegations, then anything he says can be used against him in the prosecution for the criminal case. And he would have to be advised of that fact before he testifies if there's a pending criminal investigation. What I'm going to do is I'm going to take a recess, and I would suggest that you might contact the officers that are involved in this investigation and tell them what's about to happen. I'm going to read through the file, and then when I come back, we'll take a recess for about 15 minutes and give you an opportunity to consult with those officers and determine whether or not you want to proceed with this proceeding or not. If we do, then we'll come back and we'll have the hearing, and I'll make such a ruling as I think is appropriate. But at this point, I'm going to read through the file and we'll give you an opportunity to consult with the state, with the district attorney's office or with the officers.
Okay.
We'll stand in recess for 15 minutes.
Just to court briefly, Judge, I've got the final decree. I've got some prior orders of protection that were unsuccessful. Hickman County Court wants to see those for your review.
I'm going to look at this file and this file only until we get into a hearing. You can then introduce whatever you want to.
Yes.
All rise.
All right. This story, if you'll come back up. Were you able to make any, have any opportunity to discuss this matter with any of the law enforcement?
I did speak with the detective. He is off case and she's not in the office today to be able to come in. But she said you should have a copy of the initial report in the file.
I don't have anything other than the original petition for order of protection, which sets forth a general allegation. Now, so that you understand, by statute, and this is one of the problems that is hopefully corrected by our new rotation, when an order of protection is issued on an ex parte basis, it expires after 15 days. So the temporary order of protection that was issued in this case has expired by operation of law. So it would only be your application to obtain a new order of protection that would be heard today. And if you want to have that hearing, I'm certainly willing to let you put it on, but you will have to testify regarding the basis for that, and that will have to be subject to cross-examination by Mr. Holly. Is that what you wish to do?
Yes.
Right. Then under those circumstances, because it involves allegations of sexual abuse of a minor child, we are going to terminate the live stream in this case. So give me a moment to establish that.